Hi, I'm Emily and I'm here with Maya Murphy's attorney, Ephraim J. Fink. Attorney Fink practices at Maya Murphy's Westport, Connecticut office and is admitted to practice law in both Connecticut and New York. My question today for Attorney Fink is, my grandmother was treated miserably in a nursing home and they allowed her to develop bed sores, which became septic and she eventually died. Can we take the nursing home to court?
Well, thank you for this question, Emily. Claims of this nature involve two main areas of personal injury law: medical malpractice and wrongful death. To successfully plead and prove a medical malpractice case, claimants must establish that there was a specific standard of medical care and that the negligent doctor or healthcare worker failed to employ that standard, resulting in injury. Now, successfully proving this generally requires expert testimony beyond the common knowledge of laypersons. In Connecticut, the plaintiff and their attorney must procure what's called a good faith opinion from a similarly trained, licensed, or experienced healthcare provider in the same medical field who is willing to pronounce that the defendant physician or healthcare worker deviated or departed from the proper standard of medical care in the community. Now, a written opinion satisfies what's called the detailed basis requirement if it sets forth the basis of the similar healthcare provider's opinion that there appears to be evidence of medical negligence by express reference to what the defendant did or failed to do as the breach of the applicable standard of care. When we think of medical malpractice, people tend to think of cases against thoracic surgeons or anesthesiologists, but in Connecticut, you still need experts to make out a case against non-physician healthcare workers like nurses. Let's say somebody in a rehabilitation facility and while being treated by a physical therapist is being helped to transfer a patient out of a wheelchair to do their daily exercises, and they fall to the ground. A claim against the physical therapist and rehab facility would have to be supported by another physical therapist stating that the transfer of the patient was done incorrectly, even though we don't think of such transfers as we do about the complexity of, say, brain surgery. In nursing home malpractice, such as we have here, there might be the need for two experts, actually. First, the standing medical orders in your grandmother's chart should have prescribed how often she should have been monitored and turned to prevent the bed sores, which are also known as decubitus ulcers, and whether proper protocols for that were followed faithfully. Second, after the sepsis or infection had set in, there may very well be a need for an expert to opine whether the intervention to try and suppress the infection was dealt with properly. The other area that this claim would entail is wrongful death. When a person dies as a result of an actionable personal injury, a separate claim arises called wrongful death. Under the law, it is allowable for a deceased person's estate to recover for the death of injury. In Connecticut, a wrongful death claim is simply a claim for injuries that resulted in death. Thus, it is similar to a personal injury claim. A wrongful death action is typically filed against a person or company whose negligent or reckless or intentional behavior is believed to have caused the death of another. Because the injured person is no longer available to bring the claim for themselves, for herself, another party must step in to bring the case to court on behalf of the deceased person and their survivors and their estate. In Connecticut, a wrongful death claim must be filed by the executor or administrator of the deceased person's estate. If the deceased person died without making an estate plan, known as dying intestate, that's when there's no written will, or if the named executor or administrator cannot serve, the court can appoint an executor or administrator to take over this duty. The appointee would be responsible for wrapping up the business of the estate, as well as pursuing any wrongful death claim which is owed to the estate. A wrongful death claim is a civil lawsuit like any other, which means that it must be filed by the executor or administrator directly. Liability in a wrongful death claim is expressed solely in terms of money damages owed by the defendant. So a wrongful death claim differs from a criminal case, which is brought by the state or the federal prosecutor, and in which culpability results in punishment like incarceration. In Connecticut, the executor or administrator of a deceased person's estate must file a wrongful death lawsuit within 2 years of the date of the decedent's death. In some situations, a wrongful death suit may be filed after that 2-year deadline has passed if the case meets some certain exceptions. However, in Connecticut, no wrongful death claim can be filed once 5 years have passed since the decedent's death, no matter what. So it is important to timely speak to an experienced Connecticut attorney to determine if you have a valid wrongful death claim, but you are running up against the deadlines. Damages in a Connecticut wrongful death claim are paid to the estate of the deceased person if the wrongful death lawsuit is successful in court. The amount of damages to be paid is determined by the jury or by the judge if there is no jury. Wrongful death damages may be paid for categories like reasonably necessary medical, hospital, and nursing expenses related to the deceased person's final illness or injury, funeral and burial expenses, damages for lost earning capacity, damages for conscious pain and suffering endured by the deceased before they passed away, and damages for the loss of the capacity to enjoy life's activities. I do have one final comment about wrongful death damages, particularly in light of the question that was asked. There is just a sad reality to what I call the personal injury calculus of wrongful death values placed on deceased persons brought by their estate. The family of a healthy young husband and father who was successful in his career could expect to claim a higher amount of damages than the family of an elderly retired individual with no children. Although both deaths are tragic, it would likely be easier to argue that the loss of the father was economically greater. This is because his earnings helped contribute to the household. He would presumably have lived for many more years, and his children and spouse lost his companionship and his parental guidance for all those years. In contrast, the elderly individual has already lived for many years and is presumably not contributing as much financially to the family. Of course, these are unpleasant details to discuss, but they are necessary from a legal sense because they allow the court an opportunity to assess the financial and personal impact of the wrongful death on survivors.